Orchard Grove versus Patrick Anderson.
Before we jump into today's courtroom session, here's something that makes this case far more interesting than a simple unpaid rent dispute. At first glance, you might think these are just routine eviction hearings with tenants who fell behind on rent. But as you'll soon see, Judge Simpson approaches these cases very differently. Instead of immediately pushing people toward eviction, he spends time asking questions that many judges might never ask. He wants to know not only how much money is owed, but whether there's actually a realistic path for someone to stay housed. That distinction matters because an eviction judgment can affect someone's finances, housing opportunities, and stability for years. Throughout this hearing, you're going to watch several tenants explain why they fell behind. Some are dealing with job loss. Others are confused by changing balances, unexpected court costs, or simply don't have enough income to catch up. Rather than treating every case exactly the same, Judge Simpson repeatedly looks for practical solutions. He separates current rent from overdue balances, extends payment deadlines when he believes someone is making a genuine effort, and carefully explains what each court order actually means. That doesn't mean tenants automatically win. Far from it. Property owners still receive judgments protecting their legal rights. But you'll notice the judge constantly balancing those rights against giving people one final opportunity to avoid losing their homes.
Good afternoon, Your Honor. Attorney Carrie Zan in P67390 on behalf of plaintiff.
Good afternoon. Long time no see.
I know, Judge. How are you? I was hoping to
I'm
come in
well.
person, but the weather decided to have other plans for me.
Oh, come on. We're Michiganders. Just drive through it. Or slide through it, whatever.
Slide through it. Yes, Judge. Today. That would have been that.
Patrick Anderson?
Your Honor, he's physically at the Saline courthouse. They were supposed to be signing him in.
He's at the Saline courthouse.
Yeah.
Huh.
He's not signed in yet.
But he's not signed in. He went to the Saline courthouse. They're going to try to sign him in. Oh, is that? That's not him. Hello, what's your name, sir?
Patrick Anderson.
Oh, that's him.
Yeah, I just got here.
Okay, fantastic. Okay. All right. So how much is owing on this?
$1,740.64. Court costs of $193. A total of $1,933.64. Mr. Anderson did make a $500 payment last week or beginning of this week.
Okay, so the 500 on the 25th, has that one been taken into account?
Yes, Judge, it was.
Okay. All right, Mr. Anderson, how are you going to get through? How are you going to get the rest of this spade, sir?
I make payments. I got another 500 today. That's all I can do is just keep making payments.
So you got 500 today.
Yeah.
And then let me ask you this. You can keep making payments, but if you pay 500 today, you're going to owe just shy of 1,500. How long will that take you?
Probably all of next month, to be honest.
It'll take you all of next month to get the 15. What about January's rent?
That's including covering January, including
Okay.
covering January and covering my late everything. I'll need
No. Hang on.
Okay.
If I just told you I'm not worried about January rent and you had to pay the 1,500, how fast can you pay that?
It'd take me a couple weeks at least to come up with that.
Can you get it paid by, say, the 15th of January?
I mean, if I have to, I have to. I don't really have a choice.
Okay, so here's what I'm trying to do. You pay the
Okay.
500. There's 1,500 that are owing. I may lock that figure in so that you got to just get that paid to maintain your housing, and then try to figure out January. All right.
Okay. Yep.
And that's what I'm trying to do. And I
Gotcha.
think that may be, listening to you, that may be the best way for this to work for you.
Yes.
Okay. So here's what I'm going to do. I'm going to find no tribal issue after hearing. I'm going to grant plaintiff a judgment for possession in the amount of the 1933.64. You would normally have until the 5th to pay. What I'm going to do, because I see where your payments are, or at least how you're trying to do this. over the objection of plaintiff. There's no writ until the 16th of January.
Okay.
All right. So
Yeah.
you need to get this paid and then work toward January. But this
Okay.
buys you some time. All right,
Okay.
sir?
That works fine.
All right. Thank you.
Thank you.
What we just witnessed is an excellent example of why courtroom hearings often involve much more than simply calculating dollars owed. Patrick Anderson openly admitted he couldn't pay everything immediately, but instead of making unrealistic promises, he gave the court an honest picture of what he could actually afford. That honesty appears to have influenced Judge Simpson's approach. Notice the legal strategy the judge used. He still granted the landlord a judgment for possession, meaning the landlord's legal rights remain protected. However, he delayed the issuance of the writ, effectively creating a temporary window that gives the tenant additional time to catch up. In practical terms, this isn't forgiveness of the debt, it's an opportunity. If Mr. Anderson follows through with the payment schedule he described, he has a chance to avoid the immediate consequences that normally follow an eviction judgment. Another important point is the judge's decision to separate the existing balance from January's rent. By locking in the current amount, he's trying to prevent the debt from snowballing while the tenant attempts to recover financially. That's a practical solution designed to give someone a realistic target instead of an ever-growing mountain of debt.
Orchard Grove versus Andrew Laird. Okay.
Can I stand in here?
What'd you say?
In here?
What do you want to do?
I mean, I can see it over there too.
Attorney Carrie,
Hello.
Dan.
Morning. Good afternoon. Feels like morning.
What's your name?
My name is Stephanie.
Stephanie Lair or Stephanie?
Stephanie Mack.
Okay, it's all right.
we
Okay,
have adult children together, him and I do. So I was here last Friday on Zoom.
Slow down, take a breath. You're good.
Well, I went to Celine too.
Did you?
Yes. And they were
Beautiful
supposed to
city.
be.
All right, but like, just listen. So, do you live in the apartment?
I do.
Okay.
I'm the one that resides in there. He lives in Ypsilanti.
God.
And we have a really good relationship. So thank goodness. But I was here a week ago on the Zoom with you, and there was like so many discrepancies with the numbers that they were giving me. So when I was on the Zoom, it said 81311. On this piece of paper, it said 698. And on my thing that she sent me this morning, actually, it said 795. We did speak about it this morning because I had emailed
She
for like
being whom?
Patrice.
Okay.
I'm so sorry.
Yes,
I need to
got
be a
you.
little bit more specific. I did talk to Patrice this morning because I had been emailing like the last week since Friday when I left, because I'm like, well, what number do I pay? I have this number that I got through the court, this number that I have in this piece of paper, and this number that I have on my ledger. So I didn't know which one to pay. I had been emailing her, and she said it's the 795.11, I do believe. And I talked to her this morning. I'm going to pay it on Friday.
This Friday?
Not today, but next Friday. I'm sorry. Today's Friday, right?
The second.
It's the second, yes.
All right.
So,
I was the one that
Count-
chose Christmas
Hold
over.
on. What do you have owing this thing?
I show $813.11, the amount that was placed on the record at the last hearing, and I verified that with my client. The difference, Judge, is that the service fee is different. My court costs show 193, and I think the client is showing a little bit less than that, and so that's where the difference comes into play. So it's the $18
Gotcha.
difference.
$18. That does make sense. Yes. So it is 813.11. So it does say something different on the thing that she sent me this morning.
Okay, so you're gonna get that paid by Friday the 2nd.
Yes, sir.
All right, so here's what I'm gonna do, ma'am. I'm gonna grant a judgment to the plaintiff, finding no triable issue for the 813.11 total amount. All right. And at the writ date, I can just make it the 5th of January, but you'll have it all paid.
Yes.
That doesn't include your January rent. I
Correct.
don't want to go over into January because then we're going to be dealing with that. That's why I'm doing it this way.
Yeah. So, and
So if you pay it, we're done.
yeah, the only reason why I didn't pay is because one, I didn't know I could pay it in installments. I thought it would had to be that amount number total on my check. I mean, I can pay some of it today even, but I will be paid by the second. I just don't have the 8/13/11 or the 7/95, or on this sheet of paper, it says 8/36/51. So I was confused and I didn't.
It's okay. I spend most of my life confused.
I blame it on my
All right.
controller.
It's okay. So you just now know what you need to pay.
8/13.
Get it paid. Thank you very
Thank you,
much.
sir. Have a wonderful holiday.
Yes.
New Year, because holidays over.
Yes, well, the holidays are over. I'm just getting to mine, but Happy New Year.
The second case demonstrates another challenge courts frequently encounter: confusion over the amount actually owed. Stephanie wasn't refusing to pay her rent because she wanted to avoid responsibility. Instead, she was presented with multiple different balances from different sources, leaving her genuinely unsure which figure was correct. That's a surprisingly common issue in landlord-tenant disputes, especially when court costs, service fees, or updated ledgers are added after paperwork has already been generated. Judge Simpson handled the situation by slowing everything down and identifying exactly where the discrepancy came from. Once it became clear that the differences were largely related to court costs and service fees, everyone finally agreed on a single redemption amount. That clarity is important because tenants need to know precisely what must be paid to preserve their housing rights. Expecting someone to satisfy an obligation without first establishing the correct amount would only create more confusion. The exchange also showcases the judge's personality. His jokes about spending most of his life confused helped reduce tension without losing control of the courtroom. Moments like that may seem small, but they often encourage nervous litigants to communicate more openly, allowing the court to reach practical solutions more efficiently.
Orchard Grove versus Nathan Allport. And Nathan Allport, Paul Cochran, and Stacey Allport. Is it King? Okay, so you're talking, but I can't hear you because you're muted, Nathan.
My bad.
Okay. Is that so all I have is Nathan here? All right, how much is owing?
Judge, $1,684.58. Court costs of $270. A total of $1,954.58.
How are we gonna get that paid, sir?
So I am unsure. I was a co-signer on this lease with my mother, and I don't live there. So I'm unsure how to go about this, because I am currently in my own place with my own rent. So, yeah, I know that she has roommates, and I'm unsure that, like, what their financial situation is there, but yeah.
Okay. Well, here's what I'm gonna do. I'm going to grant a judgment to the plaintiff in the full amount. That'd be no tribal issue as to defendant 1, defaults as to defendants 2 and 3 for the amount paid upon owed 1954.58 with a writ to issue in 10 days.
Thank you, Judge.
All right, thank you. And is that it for you?
This hearing is a reminder that signing a lease carries legal responsibility, even if you're no longer living at the property. Nathan explained that he was only a co-signer, had moved into his own place, and wasn't involved in the day-to-day financial situation of the apartment anymore. From a personal perspective, that may sound reasonable. Legally, however, it's a different story. When someone co-signs a lease, they're generally agreeing to be responsible for the obligations if the primary tenant doesn't pay. The court isn't deciding who should pay based on fairness between roommates or family members. Instead, it's enforcing the contract that everyone signed at the beginning of the tenancy. That's why Judge Simpson didn't spend time investigating who was living there, who had roommates, or who should morally bear the burden. Those issues can sometimes be sorted out privately later, but they don't eliminate contractual liability. Notice how efficiently this case moved compared to the previous ones. There wasn't a proposed payment plan, no realistic timeline for catching up, and no indication that the balance could be resolved immediately. Without those factors, the judge granted the landlord's request and allowed the legal process to continue.
It is, Judge. Have a happy, happy new year. And I'm glad I got to see you before the year was over.
Yes, ma'am. And you do the same.
Thank you.
Thank you. Mrs. Haverkamp versus Joshua Dent.
Good morning, Your Honor, or good afternoon, Your Honor. David Fantera on behalf of the plaintiff.
Your name?
Joshua Dent, Your Honor.
All right. And what's your claim on this case? Joshua, and I should say Sean Dent.
Yeah, that's my dad. He wouldn't be able to.
Okay.
I have recently paid 1,020 towards it. I know I said that I was going to pay the 800 by Tuesday to try to get it down. I have been trying to get in contact with Miss Valeria as well from Miss Haverkamp's, but
Hang on a second. How much are you claiming is owing, Mr. Fantera?
The total balance now is $1,733.
Okay. Got it. So they got your payment in.
Yep, we did get the payments that he referenced.
So how soon can you get this amount paid?
I'm hoping to get it paid by January 2nd. I know it's going to make this a lot
No,
later.
that's fine. So here's what I'm going to do. I'm going to take January out of the mix, and I'm not dealing with January. I'm going to grant a judgment to the plaintiff in the amount of the 1733. All right.
Okay.
With a writ date, you'll have until January 5th, that Monday, to get it paid. That'll work for you?
I'm going to make it work, Your Honor. Thank you.
Okay.
Your Honor, is that after hearing?
That's, yes, no tribal issue up here. All right, sir?
Smooth then. I have until the 5th and then
Until
am I
you
back
have
here?
it to the 5th, and then you got to worry about January. I'm not going to deal with January now.
Thank you, Your Honor.
Just try to get you out of the hole here. Okay?
I appreciate it, Your Honor. Thank you.
Not a problem. Take care of yourself.
You too.
Joshua Dent's hearing reinforces a pattern we've already seen throughout today's docket. Judge Simpson isn't ignoring unpaid rent. In every case, the landlord's legal rights are recognized, but he consistently looks for practical ways to keep the debt from growing faster than the tenant can realistically manage. Joshua had already made a substantial payment before appearing in court, reducing the outstanding balance. That matters because it demonstrates effort rather than avoidance. Courts often distinguish between someone who refuses to communicate and someone who is actively trying to solve the problem, even if they're still behind financially. Again, the judge intentionally removed January's rent from the immediate calculation, focusing only on resolving the existing arrears first. This approach benefits both sides in certain situations. The landlord receives a court judgment establishing the amount owed, while the tenant gets a short, clearly defined opportunity to catch up before facing additional consequences. It's not a guarantee of success. Joshua still has to make the payment, but it creates a realistic path forward instead of setting an impossible financial target.
Or calls the case of Mrs. Haverkamp versus Taylor Elam.
Good afternoon, Your Honor. David Fantera on behalf of the plaintiff.
Hello. What's your name?
Taylor Elam.
Why do you laugh?
I'm sorry.
Were you gonna give me a false name?
No.
No, I'm kidding. I'm just. All right. How much is owing, Mr. Fantera?
In this case, including court costs, $1,850.
It's the same as what we had before. And lady, how are you gonna get this paid?
I
Need your
have
hands
no
in
idea.
pockets,
I'm
please.
I'm still waiting for documents from my
Okay.
employer, as far as termination goes, to finish my SER.
Say
Or
again,
S-
you're,
The SER and the Hawk.
okay, so you did apply for SER. And what about Hawk?
I do have a appointment scheduled for January 13th, I believe,
January 13th? How much is your monthly rent?
$975.
And you're working, correct?
No, not at the moment.
Okay, so the problem's gonna be that you're gonna have an issue of sustainability actually for both forms of whatever. How do you see yourself getting this paid?
I really don't know at the moment, but I am looking for work. I'm tried asking friends, family, but I don't know at the moment.
All right, let's do this. Rather than have the number go up, I'm gonna find if, after hearing no tribal issue, I'm gonna grant a judgment for the $1,850. Okay? Normally you'd have until the 5th I'm gonna give you an additional week, so there's gonna be a writ not until January 12th, 2026. Between now and then, you're gonna have to try to figure it out, okay? But I'm giving you that extra time to try to figure out how you can get this paid,
Yes, sir.
okay? I've not included January in any of this, so just try to get you caught up. All right? Thank you.
Taylor's case introduces another factor courts frequently have to evaluate: long-term sustainability. Unlike some of the earlier tenants who could describe a payment strategy, Taylor openly admitted she didn't yet know how the balance would be paid. She explained that she had lost her job, was waiting on paperwork related to assistance programs, and was actively searching for employment. Judge Simpson asked questions that went beyond today's rent balance. He wanted to understand whether there was a realistic financial plan going forward. That's a critical distinction, because even if today's debt disappears, a tenant who has no income may immediately fall behind again next month. The court isn't simply looking at the present, it's also considering whether the proposed solution is likely to succeed. Even so, the judge exercised discretion by extending the deadline beyond the normal schedule. That extra week doesn't erase the debt or eliminate the judgment. Instead, it gives Taylor additional time to secure assistance, locate employment, or find another lawful way to satisfy the outstanding balance before the next stage of the eviction process begins. These decisions highlight the balancing act judges perform every day. They must enforce contracts, protect landlords' property rights, and still recognize that unexpected unemployment or financial hardship can dramatically change a person's circumstances. The challenge is determining when additional time is genuinely helpful, and when delaying the inevitable only creates a larger problem for everyone involved.
Court calls case Red Line Apartments versus William Irving.
Good morning, Your Honor. Good afternoon, Your Honor. David Fantera on behalf of.
Your name, sir?
William Irving.
All right. And how much is owing?
The balance in this case is $3,083.
All right. You said you're going to have it paid today.
Yes, I am currently waiting on a direct deposit into my account to be able to pay it.
That will pay it all off?
Right. Yes, sir.
All right. Here's what I'm going to do. No tribal issue after a hearing. Going to grant a judgment for possession for that total amount. All right. With a writ date of the January 5th. If paid today, then I'd order the case dismissed if it's paid in full.
By the 5th or by today?
Pardon?
By the 5th or by today?
If you get it paid, well, theoretically, if you get paid before the end of the month, I'd order it dismissed.
Okay.
But if your direct deposit goes, here's what I'll do. Mr. Fantera, if he pays it by the 29th, I'll issue the judgment. But if he pays it by the 29th, just send me in a dismissal.
All right.
Okay?
I'll send in a
That way,
dismissal,
the
setting
case
the
will be
judge.
dismissed. Pardon?
Yeah, I'll send in a dismissal, setting aside the judgment and dismissing the case.
Yes.
All right.
Okay?
Thank you, Your Honor.
You're welcome, sir. Have a good New Year.
You as well.
William Irving's hearing may have been one of the shortest of the day, but it contains an important legal distinction. Unlike several earlier tenants who needed weeks to gather money, William told the court he was simply waiting for a direct deposit that would allow him to pay the balance in full almost immediately. That completely changes the court's perspective. Judge Simpson still entered a judgment protecting the landlord's legal interests, but he also created a very specific path for the case to disappear if payment arrived on time. Notice the conversation between the judge and the plaintiff's attorney. Rather than forcing everyone back into court, they agreed that if payment was received by the stated deadline, the landlord would submit a dismissal that would set aside the judgment and close the case. This is a good reminder that many eviction cases don't end with someone being physically removed from their home. Sometimes the hearing simply establishes a framework for resolving the dispute. If the tenant fulfills the agreement, the litigation can effectively end before the eviction process reaches its final stage.
Court calls case of YPF 16 LLC versus Christina Morgan. And Terry Jones Jr. Hello.
Hey, Your Honor.
What's your name?
Christina Morgan.
All right. I like that. Getting greeted. Hey, Your Honor. That's how you guys want you to greet me. No. All right. Mr. Fantera,
Her balance.
how much is owing?
Her balance, including court costs, is $1,338.
Okay. gonna get this?
So I've talked to Peace Neighborhood and Barrier Busters Tuesday. Was hoping I would get a call back from them again today. She told me she'll give me a call back. But I haven't heard from them this morning. And so I was maybe hoping to get maybe another week extension to pay that balance. I am not planning on staying there after the 31st because my lease is up on the 31st.
Okay, so you're gonna move out on the,
I've already moved out.
you already moved out?
I'm in the process of getting the rest of my things out of there now, literally. I
Do
was
you
gonna
know
go,
anything about that, Mr. Fanter?
I do not.
my lease ends on the 31st.
The December 31st.
That's the end of my
Here's what
term.
I'm gonna do. I'm gonna grant them a judgment for possession. All right, finding no tribal issue after hearing. Redemption amount is that amount. You need to move and turn in your keys. If she moves and turns in her keys, I'll set aside the judgment.
But we're still gonna leave.
If
the
you move
redemption date
before
on
the
that.
end of the year, if she moves before the end of the year,
I'll be done like tomorrow.
she's gonna be done tomorrow.
So we're gonna leave the redemption date, redemption amount the same, but if she moves out or pays by the end of the year, I'm gonna do the same on this case that I did in the previous case.
Correct.
Is there a way that we could discuss the October's portion of the rent? Referee House did pay their portion, but I did not.
You can, that who did not?
I didn't pay my portion, which was only $300 for that month because I didn't have heat the entire month.
So that may have to be dealt with later. What I'm trying to do right now is just stop this from,
Being an eviction. All right, sounds good.
okay?
I'll move.
Okay, that's a, thank
So I
you.
don't need to come back to court right now.
You don't wanna come back?
I do. I
You
love,
said
I love
what?
seeing you on the
You
right
said I
cases.
don't wanna see that judge again.
On the right cases, I love being here.
Okay, all right, no, you won't have to.
All right.
You take care, have a blessed day.
Today's courtroom session demonstrates that landlord-tenant hearings are rarely as simple as pay your rent or move out. Across multiple cases, we watched Judge Simpson carefully balance two competing responsibilities. On one hand, landlords have contractual and legal rights to collect unpaid rent and recover possession of their property when necessary. On the other hand, tenants facing financial hardship often deserve a fair opportunity to explain their circumstances and, where appropriate, receive a realistic chance to catch up. Throughout these hearings, the judge repeatedly looked for practical solutions rather than one-size-fits-all outcomes. Some tenants received extended payment deadlines because they demonstrated good faith efforts to pay. Others were reminded that being a co-signer carries real legal responsibility, regardless of where they're currently living. We also saw how simple issues like confusing account balances or delayed assistance paperwork can dramatically affect someone's ability to resolve a case. Perhaps the biggest takeaway is that honesty, preparation, and communication consistently influence the direction of these hearings. While no one was excused from paying what they legally owed, the court repeatedly showed that genuine effort and transparency can make a meaningful difference in how a case is handled. What do you think? Did Judge Simpson strike the right balance between protecting landlords and giving struggling tenants another opportunity, or do you think he was either too lenient or too strict? Let us know your thoughts in the comments below. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.